Well, good morning, everybody. Welcome to the third episode of Planning for the Recovery, where we look to answer the practical questions that all of our viewers raise. And we hope to do that today with 12 specific questions. Thank you very much for all the questions that we have had. And I'll just go to the questions that we're going to ask. First one, is it acceptable for council officers to use Google Earth instead of site visits? Secondly, can officers simply rely on photographs and measurements taken by applicants? And the third one is, how do you make a material commencement to save a permission if you can't find any contractors? Fourth question is, when will the government introduce measures to extend permissions? 5 is, how do the new regulations on sill relief work? 6, what methods of data collection for 5-year land supply rather than site visits provide the robust indications for supply? The next question is, are there any appeal decisions in which COVID-19 has supported a grant of permission specifically for economic or employment developments? Question 8, can local planning authorities refuse to progress consultation on neighbourhood development plans because a physical copy cannot be made available for public inspection in local buildings like libraries? Number 9 is, how can public participation be promoted in the neighbourhood development plan preparation and examination process, consistent with social distancing? 10 is, could future local plans seek to change the distribution of housing to a more dispersed strategy given the needs for access for open space and scope for more home working? And 11, should committee members visit sites? And 12, will appellants be forced to accept inquiries and hearings being done virtually? So those are our questions. Our first speaker on the first question is Leanne, and she's going to address, is it acceptable for council officers to use Google Earth instead of site visits? Leanne.
So Chris, those that tuned in last episode, so episode 2, will recall that I did suggest on that occasion that a virtual site visit using a combination of Google Earth with photographs of the site could take place. But I didn't at that time go into any detail. So this is one of the follow-up questions that we've had from that. In short, yes, in principle it is acceptable, I think, for officers to use Google Earth instead of going out to site physically. But of course, as with everything, it will depend on the specific circumstances of each case and the information being used appropriately. So what do I mean by that? Well, just ensuring that you're conscious of how Google Maps works and the limits of it. So Google Maps has a street view feature. You can look around a location as though you're there, but it's really important to bear in mind that the images that you're looking at might not be very recent. So when you place your orange man, as it were, on the map and enter into Street View, the month and the year should also appear at the bottom right-hand side of that image, and you should also see a black box at the top left-hand side of the screen. And if you click on the clock symbol there, you can see not only the month and the year that that image was captured, but also if there's any previous images available as well, and you can choose to view those. So depending on the issue at hand, Chris, and any changes, of course, on the ground, the images might fail to reflect the reality of the site as it is now. So just need to be conscious of that. Another thing to bear in mind is as you move along a site, it could be the case that the image captured on one part was taken at a different time to the image captured on another part. So you need to bear that in mind when you're viewing the site virtually. So in my view, it's important to consider whether or not Google Earth really is appropriate for your particular site and not just rely solely on the images that you see on Google Earth, but also perhaps to consider photographs that are taken by the parties. And those that tuned in last time will remember that I said that anyone submitting an application at this time should be really conscious of that and make sure that good quality photographs are submitted with any of their applications. So in summary then, Chris, virtual site visits, yes, possible using Google Earth, but only if you think that they're capable of providing the information that's really required to decide the application. And of course, I know I keep saying this, but if a physical site visit really is felt to be appropriate, in my view, the regulations allow for it. Regulations 6 and 7 combined with social distancing guidelines would enable that visit to take place.
Okay, thanks, Leanne. Dave Chetwin has commented on the chat that as planning consultants, he says, we make clear in all our reports when site visits have not been possible and any limitations arising out of that. Obviously, officers would do the same. So, James, your thoughts on this?
So, Chris, there's no statutory requirements for a site visit, but a site visit is generally regarded in judicial review proceedings as a critical part of the defence on the basis of the application of planning judgment. So a local planning authority officer who is seeking to de-risk an application from such a challenge by way of judicial review may want to ask themselves this question in 5 parts. Is there an objection from a local resident or a statutory consultee on any of the 5 following grounds? First, landscape and visual effects. Secondly, design, for example, impact on local character. Thirdly, heritage, impact on setting. Fourthly, amenity, that's obviously in respect of proximity to dwellings. And then fifthly, sunlight and daylight and overshadowing issues. A helpful case on this is the case of Guerry against London Borough of Hammersmith and Fulham from 2018 in the High Court. And the claimant was a local resident who challenged a permission for a hotel on the basis that the officer had materially misled the committee about daylight impacts. That claimant complained that the officer should have visited certain affected properties which were going to be impacted by overshadowing. And the court dismissed this part of the complaint on the basis that the officer had conducted a site visit generally to the local area and provided their own photographs. However, the court did go on to quash that decision on the basis that there'd been a failure in applying the building research establishment, the BRE methodology, because that officer had relied too far on a specialist report. So as ever, it's probably best to consider it in this way. Lockdown is temporary, but the visible impacts of new development, of course, will be permanent.
Yeah, and I think that's a very good point. I mean, a lot of people are asking about this, but we are coming out of lockdown. Things are easing off, and certainly you can go to Barnard Castle whenever you like. And the reality is that we've always done site visits. Barristers go on site visits before we do an appeal. Inspectors go on site visits. It's a really, really important part of the whole process. And so as soon as people feel able to do it, the planning inspectors are doing site visits. Although ironically, last week they issued their first appeal decision where they didn't do a site visit. And so that has raised a few eyebrows. I suppose it depends on the nature of the case. But certainly site visits have always been part of the process because they're an important part of what we do. Anyway, that covers the first question. The second question is, can officers simply rely on photographs and measurements taken by applicants? And Leanne, I think, again, that's you. Is that right?
Chris, it is. It links to the question that I just answered. And the short answer really is no, in my view. It should be a combination of that information, tools such as Google Earth, which we've just gone through, expert plans, particularly in relation to measurements, photographs and measurements as well that are taken by locals where possible. So a whole mixed bag, actually, of information to consider there. And as I said in relation to the last question, virtual site visits really should only take place, in my view, if they are considered capable of providing the information that is required to decide the application. And if they are not, and a physical site visit is deemed to be more appropriate, then in my view, as I've said, the regulations would allow for it. Regulation 6 makes clear that you can leave your home for work purposes, and Regulation 7 in terms of social gatherings also has that exception as well. But I must stress that social distancing, of course, at the moment needs to be adhered to when carrying out those visits.
Yeah, and Giuseppe Zondra has asked the question, do planning committee members always need to do a site visit as well prior to a committee? There's a fairly emphatic no from Jack there in answer. That's right. I mean, they haven't tended to do the site visits generally if it's particularly controversial, or if they want to defer it for a few weeks, then sometimes the site visit takes place. Thea, your thoughts, please.
Thanks, Chris. Well, I agree with everything that Leanne has said, and the extent to which it's appropriate to rely on information provided by the parties will, of course, depend on the context and the nature of the application. So if it's a potential enforcement matter, then measurements might be really important. Likewise, with an application for a lawful development certificate, it might be important to understand the heights of buildings, the distance from boundaries and highways, for example, because of the different restrictions imposed, for example, by the GPDO. So I think where measurements are important to a decision, you'll almost certainly have to go on site and physically check them. Martin Miller raised a really good point as well just in the chat, which is about noise and odour. Obviously, those things can't be assessed through a screen. So if they're relevant relevant to whatever it is that's being determined, then of course someone is going to have to go along physically and stand on site to observe those impacts and be able to report properly on them. And if they can't do them, it's going to have to wait until they can.
Yeah, absolutely. We've got Warren Marshall saying the Port of Liverpool and the City Council are willing to make a decision at the Port of Liverpool. The City Council are willing to make a decision based on aerial photographs. But he does point out it helps that the application is non-contentious and there's been no objections. And I think that's a very important point, tying in with what James was saying earlier. Yeah, thank you very much, Thea. So the third question is, how do you make a material commencement to save a permission if you can't find any contractors? And that's a very sensible, practical question. I'm going to start with that. The first thing to say is that obviously the government's position on the construction industry has been somewhat ambiguous. They say they never intended to stop any construction work, but certainly the major house builders and many others believed that there was a view that it was inappropriate to carry on. And therefore, it's a very ambiguous situation. Most local planning authorities have been continuing with conditions, planning officers, including my sister, continuing to work and work continuously at home to discharge conditions and prove reserved matters and so on. So it may be said when we look back on this, well, there really wasn't much of an excuse, particularly if your permission lasted a long time and that you didn't get contractors lined up. However, if that is the case, then obviously you want to get evidence of that you couldn't get anybody, and that would be a material consideration in considering whether to grant a second planning application. But there is a great deal of case law about what is required, and it isn't a great deal, actually. There's lots of cases on this. One case in particular is the Malvern Hills case, where the pegging out of an access road was considered enough, so you wouldn't really need contractors for that. I have to say, I would envisage that people would do a lot more than that. The advice we usually give is to do more than is required. You don't want to end up in court arguing about whether there was a material commencement. But certainly that will fit into the general view that people should have got on with it rather than let it go, because it will be said that very little was actually required to achieve it, even if you couldn't find contractors. Obviously, it all depends on the circumstances of the case, but that is plainly relevant. And Jack, your thoughts on that?
Yeah, Chris, it seems to me the biggest hurdle is likely to be discharging pre-commencement conditions in time. Actually commencing development as a doddle, as the threshold is very low. And as we've explained in the case law, it's littered with examples of how little is actually required, including, as you say, pegging out the land or digging a trench. And it seems to me there's no reason why the modest works required to satisfy commencement necessarily need to be undertaken by contractors.
Okay, thank you very much, Jack. Then our fourth question is, when will the government introduce measures to extend permissions? And that's you again, Jack, yes?
Yeah. Many in the planning world, including you, Chris, have been frustrated that the government has not pulled its finger out and copied what's been done by the Scottish government. The emergency measures in the Public Interest COVID-19 Act of 2020 and the new Section 25(1)A of the Planning and Development Act 2000 both provide a blanket extension of 6 months to permissions expiring around this time. So that's what they've done in Scotland. How could this be achieved in England and Wales? Well, there are a number of ways to skin the cat. One way would be to amend sections 91 and 92 of the Town and Country Planning Act that regulate the time limits. Or you could add a freestanding section extending the time limits. A second thing which could be done would be to add a permitted development right. So you could amend the GPDO to provide a new class of permitted development, allowing that to be permitted for development undertaken within 6 months of the expiry of the planning permission. And this permitted development right would need to be conditioned to ensure that the conditions from the original planning permission carry over and apply, including any planning obligations. Another way which it could be done would be to issue guidance reminding local authorities that they have a discretion under Section 2 of the 1990 Act to extend the default 3-year period when granting new permissions at this time. Or they could publish guidance to confirm that in these exceptional circumstances, an extension of the time limit imposed on a permission by way of condition may be considered to be a non-material amendment as far as Section 96A is concerned. So that's what could be done. Will the government follow in Scotland's footsteps? It's not quite as simple and as straightforward as it first appears. So first of all, what is the scope of any extension? Will the extension apply to all permissions? If so, will it have a retrospective effect so as to apply to those permissions which have elapsed post-shutdown? Secondly, the changes will have to be reconciled with different environmental regimes. So this may require some nimble footwork by parliamentary draftsmen. For example, what would happen to a permission which was granted at a time when the baseline conditions were different? If a lapsed permission is to be revived by a change in legislation, this will create a new chapter in the planning history. How does one create a fresh permission without triggering the need for screening or for new information? So all of these are surmountable, but does require considerable care.
Yes, I couldn't agree with you more, actually, Jack. And, sorry, I'm muted. James, you.
So, Chris, what more can I add to such a comprehensive summary from recently appointed Deputy District Judge Smythe, sitting part-time? I think, very briefly, the Section 96A route is interesting, but it's likely to be highly controversial and will end up in litigation. So proceed with extreme caution before taking that non-material amendment route. Secondly, the central problem with planning primary legislation, i.e. acts rather than regulations, has been with us for some time, at least since 2010 in my recollection. And effectively, there are three issues here. The legislation takes considerable time to draft and consult on internally before it even makes it to Parliament. Thereafter, parliamentary time to consider that legislation is in short supply, particularly bearing in mind that the ministerial portfolio is so wide. And thirdly, that legislation can then often be respectfully hijacked at the parliamentary stage due to the political controversy of the underlying subject matter. See, for example, the various add-ons in respect to the requirement to take account of neighbourhood plans. So in short, what we have here is a pre-lockdown constitutional problem, which has developed an acute character for the planning system during the current crisis.
Yeah, absolutely. And nobody can say for certain. Now, I've been in contact with Simon Gallagher, who is the Director of Planning at the Ministry of Housing, and he says, be patient. A number of people from the Development British Property Federation believe that they have been given an indication that this is coming. So we think it is going to be soon. That we follow Scotland's lead, but of course it hasn't happened until it's happened. So hence all those very sensible questions beforehand about what do you do if there aren't contractors and what is required. Can I just say, Rebecca Warren of Crest Nicholson also asked, if you are going to carry out some pre-commencement works, is it better to agree that with the authority beforehand? And as Thea and I and everybody would reply, I think, the answer is undoubtedly yes. Well, not binding on the officer is obviously very difficult if the officer then said, well, I know I said this, but actually what I meant was that. So a very good idea there, Rebecca, to get it agreed with the authority. OK, we're going to move on to our fifth question. How do the new regulations on sill relief work? And back to you, James.
So, Chris, the guidance issued by government from 13th of May of this year simply states, with my own numbering, that the government's going to introduce amendments to the sill regulations to, one, enable charging authorities to defer payments, so that's deferral. Secondly, to temporarily disapply late payment interests, so that's disapply. And thirdly, to provide a discretion to return interest already charged when it's considered to do so for developers that have an annual turnover of less than 45 million. So defer, disapply and discretion. And each of those will require 3 core amendments to the SIL regs. Firstly, an amendment in respect of payment for SIL in instalments, possibly supported by changes to the definition of the commencement date in respect to Regulation 70. Second, an amendment to Regulation 87 in respect of the automatic requirement to pay interest at the annual rate of 2.5% above the Bank of England base rate from the date that payment was due. And thirdly, there's likely to be a new set of provisions in the regulations conferring a discretion on the payment of interest. And that's probably where much of the battle will be had in the early days, including, for example, as to the correct calculation of the company's turnover, and of course whether such entities have any kind of substantive legitimate expectation of repayment in light of the government guidance. So, as above, MHCLG must act quickly here, but one cannot expect anything for a number of weeks. It can be recalled that the initial amending regulations in 2019 took over a year to bring forward from consultation to publication. This is grade A, double black diamond difficulty legislative drafting. And all of that spells a very careful descent down this particular mountain.
Yes, I couldn't agree with you more, James. And Thea, your thoughts on this?
Yeah, well, I mean, SIL's one of those things that, unfortunately, I could talk about all day. I'm a bit of a SIL geek, having been involved in the SIL review that started in 2015. And that review found that other than in London, coverage was patchy and the levy really wasn't working. The whole system was found wanting and some really radical reforms were proposed. But that led to, frankly, very limited reforms last year. One of them, as we know, which I think was a really welcome reform, was the removal of pooling restrictions, which was introduced originally to incentivise local authorities to adopt the SIL and encourage a move away from Section 106 obligations. So just looking at the whole SIL regime, I don't think that coverage is going to improve. The system is still relatively inflexible and incapable of doing what it's set out to do other than in very limited areas. What I find really interesting about the guidance issued on the 13th of May is the clear statement that there are greater flexibilities with Section 106 planning obligations than SIL, which is obviously right, but it does highlight the advantage of 106 agreements or unilateral undertakings over the present SIL regime. Now, in respect of 106s, the guidance says that local planning authorities should take a pragmatic and proportionate approach to the enforcement of obligations during this period. Obviously, that's straightforward to do. It doesn't require new legislation, and it's not difficult for local authorities to do that in order to help developers out at this difficult time.
Okay, thank you very much, Thea, for that. The next question is what methods of data collection for 5-year land supply provide the most robust indication of supply? Now, my view is that you plainly can go on site as long as you're practicing social distancing. I was out on site the other day looking at a site for Gladman, and immediately adjacent to that was another site which was being built on, and they had the signs up for the social distancing and how they were going to perform. So it is entirely possible to go out on site. As I say, inspectors are doing this, barristers are doing it, and so on. And I think it will be difficult in the end to be able to say that it wasn't carefully monitored and examined. The methods of data collection should continue as they were, but inevitably, because of the changes in what's happening, it would be important to speak regularly to the developers and to speak to developers about what is going on their sites. That communication on a weekly basis, I think, is incredibly important. But James, your thoughts on this?
So, Chris, I agree with all of that. It's a tremendously important topic for the future, how we properly document progress on a site. Now, the answer about how one documents that and the level to which one documents it will depend, of course, on which side of the debate you're on, whether you consider that in a given case supply is going to increase or decrease in a given authority. Now, of course, much of the real debate will centre on those sites which are simply outline consents or allocations in adopted plans. And we recall here that the PPG, in respect of annual position statements, requires authorities to look to current planning status, timescales, and of course progress towards detailed permissions. And then in respect more generally, the PPG then looks in respect of current planning statements, status to planning performance agreements, in respect of firm progress being made towards the submission of an application, a written agreement between the LPA and the site developer, evidence of firm progress with site assessment work, and clear relevant information about site viability. So irrespective of the question of whether one can go on site, I would still expect there to be a need for LPAs to ramp up their officer engagement on this issue and ensure that there are documents within those categories named in the PPG. So written agreements, as set out in the PPG, have never been more important. That's written agreements backed by site reports from the developer and photographs from site, because in due course this process will have to be automated and perhaps even then thereafter supported by drone footage to confirm numbers on site. Secondly, then, complete list of correspondence discharging any conditions, neatly packaged, not a mass of emails. And thirdly, reports from companies confirming the return of workers on the individual site, perhaps supported by the new health and safety reporting requirements. So an LPA who wishes simply to use the crisis to go back to the bad old ways of simply providing a series of emails from a developer confirming that everything's back to normal, as under the NPPF 2012, that's not enough. It's time to recognise that the process of housing land supply calculation is not about writing short story fiction. It's a serious audit, it's a stocktake, and it needs to be carefully measured against past delivery predictions.
Okay, thank you. Thank you very much, James. And I have to remember to take the mute off all the time. So our question 7 is, are there any appeal decisions in which COVID-19 has supported the grant of planning permission, specifically for economic and employment development? Thea, your thoughts on that?
Thanks, Chris. Well, I did a search for those decisions that contained the word COVID, and that brought up 104 appeal decisions. Now, one of the most significant of those is the one that we covered in episode 1, the decision of Christina Downs land north of 9 Mile Ride. And that was a decision where, Chris, as you know, the inspector had regard to the current crisis as a reason to reduce the housing land supply. Now, in respect of the decisions I've read that came up in my search, most of them were enforcement decisions, and the benefit to the appellant was that a longer time was given for compliance with the notice, particularly where that involved demolition and site clearance. Now, there was a further interesting decision for housing in Wrexham, where the appellant said that the pandemic supported their scheme for new housing, because once the COVID-19 impasse is removed, it will be at that time a scheme like this will be needed more than ever to restore economic investment, provide new homes and secure jobs that have been mothballed. The appellant said in their opinion that translates to suggest that economic considerations must more than ever be given significant weight in an appeal. Now, the inspector, however, said that while the pandemic had caused a worldwide economic slowdown, the economy is subject to such ebbs and flows, and therefore the situation was not exceptional in itself. So the answer to the question is no. So far as I'm aware, there have been no appeal decisions in which COVID-19 has supported a grant of permission specifically for economic or employment development. But I stress that is a yet. I think there are bound to be such decisions in due course. But we don't yet have the evidence of the economic and social impacts of the crisis to make a really cogent case. I think parties need to keep a close eye on what is happening with that evidence base and be prepared to make submissions in due course, because I suspect the question is going to crop up at inquiries and hearings for months, possibly years to come.
Yeah, I completely agree. I think it's a little bit too early because we don't know what the state of play is with the economy and how significant that is. really this is a macroeconomic issue. This is for the government to decide and to issue a written ministerial statement if they do want to go back to where they were in 2008, which is to focus on the delivery of new houses as part of economic growth because of the economic downturn that was then there and which we're now experiencing now. There is suggestion, I should say, that there will be a written ministerial statement addressing this very issue shortly, but whether that's part of the rumour mill or whether that's actually true, have it on reasonable authority, that's what we're going to see. I think the government will be becoming increasingly concerned about the state of the economy as this progresses. And I think we are likely to see something very positive in that respect. But of course, we just don't know. It obviously will be highly significant for certain types of development distribution. If patterns change in terms of shopping and so on, then we'll see certain types of developments being identified as sort of a consequence of COVID-19. But we wait to see and wait to see what the economic data is. And frankly, we all hope it isn't as bad as some people feared it might be. Right, we move on to our next question. And question 8 is, can local planning authorities refuse to progress consultation on neighbourhood development plans because a physical copy cannot be made available for public inspection in local buildings like libraries? And James, you're going to answer that one to start off with, please.
So, Chris, my view is the short answer is no. The neighbourhood planning regulations in 2012 adopt a very light touch approach to physical inspection requirements. That the test for publicising decisions and consulting on area designations, pre-submission plans, post-submission examination plans and decisions is to publish on their website and in such manner as they consider is likely to bring the application to the attention of people who live, work or carry on business in the area. And that's generally followed by a requirement then to publicise details of where the relevant documents, inverted commas, may be inspected, where Regulation 3 of the regulations defines inspection simply as inspection by the public. So in practice, any court faced with a challenge on this kind of issue would take a very practical approach and ask exactly how a claimant in that challenge who was seeking to rely upon this provision had been impacted, how they'd been prevented from inspecting the document. Now, it's vitally important that we don't assume that members of the public can all access the internet with ease. But here, the threshold of consultation in this context has been set by Parliament in a very flexible, very pragmatic way. And I think that reflects its 2012 origins as compared to, say, the EIA legislation, which has a slightly older genesis in the 1990s and before. So in short, this could be easily cured by providing a physical copy to the individual in question through simple post and perhaps extending the deadline for responses on a bespoke basis. But not to proceed at all wouldn't be in accordance with the regulations on my reading.
Okay, thank you very much, James. And Leanne, your thoughts on this, please.
So, Chris, I agree actually with James's interpretation of the regulations and the discretion that's within them. And I'd just point out as well that the NPPG can help us in relation to this. Now, there's going to be slides circulated after today that will have the reference on there. It's paragraph 107. And that emphasises, first, that it isn't mandatory that engagement is undertaken using face-to-face methods, and also that it isn't mandatory for copies of documents to be made available at a physical location either, and they can be available online instead. But that said, as James has pointed out, the PPG also does say that you need to demonstrate that all groups in the community have sufficiently engaged, such as those without internet access, as James has picked up upon, and more targeted methods might be needed for those persons, including telephone and writing. So it is clear that sensible thought does need to be applied in terms of how practically one reaches the wider community, but sufficiently engaged doesn't mean every single person needs to be reached. Plainly, alternative methods do need to be available, and I think James's suggestion of being prepared to provide physical copies and extend deadlines is a wise one. I also note finally, Chris, that the PPG does suggest that LPAs might be able to advise neighbourhood planning groups on suitable methods as well, both in terms of reaching certain groups in the community, but also providing communities with access to physical copies of documents as well. So neighbourhood planning groups should go to their LPAs, and LPAs should be providing that information for them.
Okay, thank you very much, Leanne. And we move on to our ninth question then. How can public participation be promoted in the neighbourhood plan preparation and examination process consistent with social distancing? And over to you, Jack, for this.
Yeah, the regulations which accompany the 2020 Coronavirus Act means that no elections or referendums can take place until the 6th of May 2021. And that's the reason why a number of the mayors have had their terms extended, like the Mayor of Birmingham. But this prohibition includes neighbourhood plan referendums, and these provisions will be kept under review and may be amended or revoked in response to changing circumstances. In the meantime, the updated current planning guidance sets out that neighbourhood plans awaiting referendums can be given significant weight in decision making. The guidance, which was further updated on the 13th of May of this year, also provides further advice on the implications for conducting publicity and consultation and examinations. So it seems to me that the regulations can now be revisited. I can see no reason why a socially distant referendum cannot take place. Alternatively, a postal-only ballot. It seems to me it would be needlessly cautious to continue the blanket ban on all referendums across the whole of the country for another 11 and a half months. But of course, the referendum is the final staging post on the journey. There's no reason why neighbourhood plans cannot proceed so that they are oven ready for referendum as soon as the government allows. Site visits can be undertaken by consultants, meetings can be undertaken remotely, and in due course, consultation and in-person meetings can take place. I don't anticipate that the restrictions which are likely to stay in place the rest of this year should prevent neighbourhood plans progressing.
Yeah, absolutely. I mean, I think the choice of putting it back a whole year was just extraordinary, and nobody really understands. Nobody could know what the situation would be in a year's time, let alone for the prospect of just simply voting. Leanne, your thoughts on this?
Yeah, Chris, I agree with Jack, in short. In principle, I don't see why referendums in the appropriately socially distanced form can't take place, obviously subject to an amendment to the regulations that Jack's referring to, so Regulation 13 of the 2020 regulations. In my view, referendums are perhaps more vital than a number of things that we are now able to do. So, for example, the Amendment Number 2 regulations allow us now to take exercise, visit a public open space with a member of another household. We can undertake a number of activities in connection with the purchase of property, including going for viewings at potential homes, and we can visit garden centres. In addition, government guidance, and I should say not to be confused with the law, of course, seemingly allows us to drive any distance that we like for exercise, go on day trips and exercise as many times as we want to in one day. And it also would appear that we're set now to move into the next stage of the government's plan, which will see children returning to school in phases at the beginning of June, and non-essential shops opening their doors as well. So plainly there will be people that want to participate in a referendum, and they should be able to do so. There will be some that need to shield still though, so Jack's suggestion of a postal ballot I think is a good one. And I'm certainly of the view as well that in addition to the regulations that Jack speaks of being amended, it would be helpful for there to also be a suitable amendment to the Health Protection Coronavirus Restrictions England regulations if ballots are going to take place. Because although, of course, the list of reasonable excuses there isn't exhaustive, there has plainly been confusions, I think, we've all seen in the media and social media and in paper form from all parties about their applications. So a clear, reasonable excuse of attending ballots or posting or what have you would assist with that, I think. Government guidance is helpful, but it isn't legislation.
Yeah, and I mean, it all seems extraordinary, doesn't it? As you say, some of the contradictions, many contradictions are rising now, and we're seeing a whole variety of things. Why don't they just hold the referendum in a garden centre? You know, it seems to be a pretty obvious way to do it. If thousands of people are going there, why can't you do it in a garden centre. Maybe the same for inquiries, I don't know. Okay, we move on to our next question. And question 10 is, could future local plans seek to change the distribution of housing to a more dispersed strategy, given the need for access to open space and the scope for home workings? Now, this question is very interesting, and whilst, of course, we all enjoy the technical detail of material commencement, this allows us to think a bit more about what a lot of people enjoy in terms of planning, which is to think about how planning can shape the way we live. My own view is that although there's a lot of talk about changes, it isn't going to be possible to achieve some of the things that people want. So, for example, lots of people may now think that it would be entirely appropriate for everybody to have a garden, but that's not going to happen. The government's emphasis on previously developed land means that there's no way that's going to be possible. And so the idea that radical change will happen to the dispersal and location of housing when we've had years of focusing on sustainable development, focusing on the larger settlements, focusing on previously developed land, I think is unlikely, although obviously some applicants will raise it. I think where we will see changes is possibly the use of road space and see more space for cyclists, not just on a temporary basis, and pedestrians as well. However, this is a terrible pandemic that may yet happen again, and we don't know, and let's hope it never does happen again. But if this were to happen a second time, then I think a serious look would be taken at the idea of dispersal and making sure that people did have more space and did have private gardens, and to make that a condition of every form of new home. That might be possible. We certainly only have developed 11% of England, and so there's plenty of space out there. But for the moment, I think whilst applicants may raise this, we're unlikely to see a move away from flats. But I may be wrong. Who knows? Some councillors may think we've had enough flats already. So I'll pass that question over to Jack as well.
Chris, just to pick up your last point, a countervailing pressure against the appetite to have more dispersed living with gardens is it's likely to be a rising number of vacant office premises which could be converted into residential accommodation as permitted development. There are big advantages, as we all know, for developers for going down this route because there's no sill, there's no requirement to provide affordable housing, and there aren't the associated infrastructure contributions. And secondly, developers are not obliged to follow minimum space standards, so that gives an element of flexibility. And this has been ventilated by the tabloid press, which talks about windowless dwellings and all the rest of it. But it seems to me that whilst there's likely to be a demand towards more outdoor space, this will be accompanied by an increase in supply of city centre residential accommodation. And so maybe they dovetail quite nicely in the sense that if there's a nice stream of supply of residential conversions in city centre, it means that the local plan needs to do less of the heavy lifting in that regard and can focus its attention on providing more of the dispersed living, which people may have more of an appetite for.
Good, thank you very much, Jack. Now, the next question is one which we get asked a great deal about, which is, should committee members visit sites? Now, you may feel we've covered some of this material already, but this specific question relates to the fact that members are having virtual meetings, but should they actually go on site? And so, Leanne, what's your view about this?
So, Chris, there's two stages really. I think really before we look at whether or not they should visit site, it's probably important to consider whether they could visit site and whether the law allows for it as a matter of principle. And I know that I've said multiple times already on today's show and in the last episode as well that the health protection coronavirus restriction England regulations would allow site visits to take place provided social distancing can be adhered to. So regulation 6 subparagraph 2f allows you to travel for the purposes of work where it isn't reasonably possible to work from the place where you're living. Well, of course, site visits would fall within that in my view. And of course, regulation 7 deals with restrictions on gatherings of more than 2 people. But again, Chris has the exception where the gathering is essential for work purposes. So in my view, Clearly, legislation would allow it, they can. So whether or not a site visit can take place depends on if its completion is needed as part of one's work, if more than 2 people attend, that gathering is essential, and if it's safe, so if social distancing can be safely adhered to. And of course, Chris, I touched last time on PIN's updated guidance, where they've now made clear that they're going to be commencing site visits where it's safe to do so as well. So as a matter of principle, committee members can visit sites. Moving then to the second part, whether they should, again, Chris, it really depends on the need in a particular case, and I think it would be sensible to first consider whether or not the site actually requires a visit, because of course not all do. Site visits are of course there to help committee members understand the details of an application in context, but more often than not the information that they need to determine an application is in the papers anyway, and in those sorts of cases then no, if it's not needed, they shouldn't be visiting the site. It's not a reasonable excuse. But of course, if it's an application that's more complicated or contentious where a site visit is required, then in my view, that would be a set of circumstances where they should visit the site, and it would be a reasonable excuse under the regulations. Of course, we've touched today, Chris, haven't we, on virtual site visits, and so it is important, I think, to consider whether that would suffice, and if it would, then the need for a physical visit is gone. And finally, if you are going to visit the site, think about who needs to be there. It might not be the case that all members of a committee need to trudge down to the site. A reduced number of members might be able to visit instead.
Okay, thank you very much, Leanne. And I would just add to that a comment from John Williams, which John says, some councils, in his experience, are taking video recordings of sites and displaying them at the virtual meetings. So that is what some councils are choosing to do. Okay, we move to our last question then, and one of particular interest to this particular panel, which is, will appellants be forced to accept inquiries and hearings being done virtually? Thea?
Yes, I think is the really straightforward answer, Chris. You will have to do digital hearings. The first digital hearing was held on the 11th of May, and while PINS has come under fire for being a little slow to get started on digital hearings, it does seem that there is a desire to crack on with this now. Now, Chris, I know you spoke to the Inspector in charge of appeals yesterday, and he said that PINS have gone to all events being virtual. They've suggested doing so on the basis of the safety of their inspectors. There's no end date to virtual events, but it is acknowledged that those are tiring and not what people want to do permanently. There are all sorts of reasons why digital hearings and inquiries would be, I think, less good than an in-person appearance. There is a suggestion, however, that we will get hybrid events in future, but the message is clearly it is full steam ahead. Digital hearings aren't going away, and I suspect you're going to need a really good reason not to do a virtual hearing. We simply have to get ready and set up for those sorts of hearings. And as I said in the last webinar, it's really important to get your tech right. Now, as I said, I'd love to hear from people who are attending, if they were involved either in the first hearing or if they've got hearings coming up, and for them to share their experiences, because I think that shared knowledge and any lessons that we can learn from the process are going to be really useful for all professionals involved in digital inquiries and hearings.
Great, thank you very much, Thea. And Jack, your thoughts on this as well, please.
I agree with Thea that it's unlikely any party will have a veto. If a party wants to adjourn a virtual hearing or inquiry, it will have to provide a cogent explanation. A generalised preference for an in-person inquiry will not cut much mustard, and ultimately it will be a matter of discretion for the individual inspector. I had a 2-day hearing listed for a week or so ago, which got pulled even though both parties were keen to proceed, the inspector pulled it on the basis that it was raising quite technical issues about 5-year supply, and lots of new evidence had been provided by both parties at quite short notice. So I think in those circumstances, the inspector was reluctant to proceed, but that was one of the very first hearings to be listed, and I think the appetite to keep the show on the road and proceed will carry on. And the final thing I would say is just to reiterate a point I've made previously, which is appellants really have nothing to fear from virtual hearings and inquiries. In many ways, they've got a tactical advantage over local authorities because they probably have the support and resources and technological wherewithal to deal with that platform better than many local authorities are.
Yeah, we certainly know and have heard stories of some authorities where the staff are yet to receive some of the technology that they need and some of the equipment they need. I'll just add, if I may, to this, what I think has happened, which is that PINS were suffering from a real problem of asking for candidate inquiries and hearings and then having one party object, whether it's the local authority, might have been the developer or residents. And so they were in a complete impasse because they couldn't proceed on that basis because somebody was objecting. I think what the minister making his statement, Robert Gendrick, has done has meant that PINS can now say, well, the default setting is that it's an inquiry that is done virtually or a hearing done virtually. And the minister suggested and PINS have suggested only in exceptional circumstances will not take place. So that has dealt with those who are seeking to stop inquiries going ahead at all. And that's very, very positive. At the same time, the minister announced that 20 were going ahead at the end of May and June. And I asked at the planning inspector whether that was the case and if they could tell me the cases. I think what's happened is to make sure that there are 20, they've turned everything that was going to go ahead in June into a virtual event. And certainly I've got 2 case management conferences today where we're going to have to change from a real event because the parties were happy with that to a virtual event, which I think is unfortunate because you can certainly do these inquiries in large venues with social distancing. But as it stands, it's virtual for now. There is no answer as to when the virtual proceedings will end. And I think we just need the government to be clearer. My own view is Boris has said we'll be back to normal in July. And really, as late as September, I think we should be back to normal events. I certainly hope that's the case. Okay, well, that's all of our questions answered. Thank you very much from me and from all of the panel. Thank you very much for everybody who joined us. Do send in your questions to us or marketing at Number 5 Chambers so we can address them. We'll be back in 2 weeks' time and look forward to answering your questions then. So from all of us, goodbye.